Hello and good morning. Welcome to this Keating Chambers live webinar on Med-Arb and conciliation. Thank you for joining us this morning. My name is Oliver Goldsmith and I am the Arbitration and Mediation Clerk here at Keating Chambers, and I manage the ADR practices at Keating for those individuals and those including our mediators. And I am fortunate enough to be able to clerk both of our speakers that are taking part today. Over the next 45 minutes or so, Robert Gateskill QC and Rosemary Jackson QC will consider Med-Arb and conciliation, including what they are, why they work, and problems to watch out for. This will be followed by a Q&A session, so please do submit any questions that you may have for our speakers using the Q&A box, which you should find on your screen. Now, the first challenge I have this morning is to introduce a gentleman that probably needs no introduction, but I'm going to give it a go, and that individual is Robert Gateskill. Robert Gateskill is a dual qualified engineer and QC, and he has an extensive international mediation and arbitration practice. And in his spare time, which is probably not a lot, he is the editor-in-chief of Keating Construction Dispute Resolution Handbook. So I think that's enough from me until the Q&A session later on. And so I'll now hand you over to Robert. Thanks very much.
Hello, everybody. I know we're all in different time zones, but wherever you are, welcome to this session. I've looked at the names of the attendees and I can see many old friends there. So it's very nice to be in contact with you in these strange COVID times. What I'd like to do at this point is simply to introduce Rosemary Jackson QC, who is going to give the first presentation. She'll be speaking about mediation and conciliation, the two aspects, that's facilitative and determinative mediation. And there is no one better than Rosemary to speak about those subjects. Rosemary must be at least one of the top mediators in the common law world. In construction mediation, I would be surprised if she has any peers at all. She is remarkably successful and adept and popular with clients throughout the world in her field. So no one better than her to speak to you. Her abilities as a mediator are recognized by all the main directories, Chambers Directory, Legal 500 and so on. So there's really nothing much to say beyond that you're going to be getting the update on the position from somebody who really knows what she's talking about. So over to Rosemary.
Good morning, good afternoon, good evening. I'm going to be talking about conciliation and its kissing cousin, evaluative mediation. I'll just say a little bit about that to put things into context. But conciliation is my main topic today. And Robert's going to talk to you about Med-Arb. And I think it's important to note there are two things about Med-Arb and conciliation. They both have mediation at their core, and they're both seeking to add value to that process one way or another. And the other thing I think is important to note is they both have the ability to mean completely different things to different people. Robert's going to be talking to you about how people use the phrase Med-Arb to mean completely different things, from a procedural mechanism to aid the enforcement of a mediation settlement, right through to a formalised process where one person's wearing two very different hats to perform two very different roles. And the latter of those, as we shall see, is really very like conciliation, hence me talking about this first. So I think, given that mediation is at the core of all of this, we should start by being clear about the reasons why mediation works so well. What are the prerequisites? And I'm talking here about facilitative mediation. I know there are some mediations and some mediators, particularly in jurisdictions outside the UK, where the mediator is very directive and decisive from the start, pretty much telling people what their settlement needs to be. And I can imagine all sorts of ways you could turn that into a recommendation. But that's not really what I'm interested in talking to you about. My interest is in how value can be added to a facilitative mediation. What's the qualitative change? So for a facilitated mediation to work well, the mediator needs to build rapport with the participants in order to gain their trust. That's really important. And then in addition to that, the safety net that's provided by the confidentiality and without prejudice protection of the mediation process also enables the parties to have honest and open exchanges with each other and with the mediator. So these four qualities of a mediation, rapport, trust, confidentiality, and without prejudice protection, to me are key. They make it possible for the parties to feel safe enough to share privately with the mediator their real views about the strengths and weaknesses of their case and what their needs are, and to be assisted towards a deal that they can shake hands on, bang elbows on, or just wave nowadays on Zoom. It also enables them not only to listen, but to hear what the mediator says when testing and guiding them through the negotiation, because their only aim is to find a settlement. That's what they're focused on. And I often tell mediating parties that if they're able to trust me and be honest with me, I may be better able to help them get where they need to be in their negotiation. They're then going to be able to go on to own the settlement that they've shaped to reflect their strengths, their weaknesses, and their needs, and also the reality of the situation, the art of the possible. So that's trust and rapport. It's really important to make people feel safe. And then you've got the confidentiality and without prejudice protection. One of the great advantages of that is the parties feel secure enough to identify which of their claims are strongest and which are less good and which can be parked for the day. Instead of fighting on all fronts and insisting not only to the mediator but to the other party that every point's 100% winner, they can acknowledge their weaknesses because it's a without prejudice process, and they can get on with the big issues that may unlock the dispute. They can say, I still think I've got a good argument on this, it's not my best, let's park it for today. And they can do that, knowing that it won't be thrown back at them at a later date. When the mediation ends, it's as if it never happened. We all go up in a puff of smoke. So to me, that's the gold standard. Honesty, openness, trust and rapport, enabling parties to make their settlement in mediation. And in my experience, on the whole, in fact, in all my mediations, as far as I know, when they've made their own deal, they will honour it. I appreciate that's not always the case in all mediations. Conciliation, on the other hand, is slightly different. It's usually mandated by the contract that the parties have, and it involves the very same facilitation process as a mediation, but with an add-on provision that if the parties are unable to reach a settlement, the conciliator changes from facilitator to some sort of decision maker, recommender. Typically, there'll be a provision for the conciliator to provide a recommendation. It might be non-binding. It might be one which becomes binding after a stated period of time if neither party objects. And sometimes that's what happens. It could occasionally be a binding recommendation, but that I would have thought is much rarer. And you've strayed into Med-Arb probably if you're doing that. It's very important, I think, to look at what it is the recommendation is meant to be. Obviously, you look at the contract or the procedural rules that you're working under. It may, for example, provide for a recommendation on the basis of the basis on which the dispute ought to be resolved. And that sounds very easy until you start thinking about it a little bit more. If there's doubt about what that means, I would have thought it's wise to agree in advance with the parties what it is that they want by way of a recommendation. Because the more you think about it, the harder it is. What does the basis on which the dispute should be resolved mean? Does it mean the conciliator's view of the merits? So very much, this is the right answer. I've analysed it all. If you're going to have that, you'd better hope that you've chosen a neutral who is not only someone with the people skills to facilitate the mediation part of the process, but also the acumen and the sector expertise to analyse the issues and reach the right answer. There are a lot of people who can do one or both of those, but not everybody can do both. Another recommendation might be, what's the conciliator's view of a fair outcome? Having heard everything, this seems to be a good way of resolving things. That might be what the parties want. And then the third possible way would be the conciliator's view, bearing in mind everything they've learned confidentially during the process, of what would be an achievable outcome. And that's possibly the most useful. It's possibly the hardest, because a fair outcome that one of the parties can't afford is not worth having. Whereas an outcome that you think the parties could actually sign up to might be very helpful for them. If you know something, see privately from one party, that shows that an otherwise sensible settlement isn't possible, you might be able to recommend something really useful instead. It's quite difficult to do that, mostly because it depends on confidences that have been shared. And obviously you can't have a decision or a recommendation in writing that breaches those confidences. So that sort of recommendation is usually very light on reasoning. But these are all valid approaches. And what really matters, I would have thought, is what the parties think will be most helpful to them. You've got to be focused all the time on what it is they want, what will help them get this resolved so they can walk away and close their files. I think it goes without saying that the last of those options, which is what can actually be done, what is the art of the possible, is very confidential. And it also may put the mediator, conciliator in a slightly difficult position. They've got to take on faith what they've been told, and it's entirely possible someone's pulling the wool over their eyes. Someone who says, look, doesn't matter what you say, I simply don't have the money in my company, I cannot find more than £1 million. They may be telling the truth, they may not. And mediators all have the experience of parties saying, that's not possible, it's inconceivable that we could do that, that would be crossing a red line, only to find the parties do that several hours later to get a deal. So there's got to be an element of trust, and it can be quite a difficult line to tread there, to know what you can believe and what is really the art of the possible. But that I can see is something that you need the same person for. The mediator has heard all the confidences and is the only person who at the end of the day could be saying, this is what I think is possible. That's fine. It's the other two options that trouble me more. The conciliator's view of what is the right answer or what is a fair outcome. And I'm troubled by that because you've got a neutral person changing hats mid-process. They've been a facilitator to whom you can say anything. Now they're a person who could potentially be changing your legal rights. And that's serious. I should say, because I don't want to sound completely negative here, my conciliation appointments have generally resulted either in a settlement during the early process without the need for a recommendation, or in a recommendation that the parties have accepted, either in whole or with some tweaks that they can agree. It's very successful by all accounts. And I would welcome your suggestions in the question and answer box as to why you think conciliations that you've been involved in have been successful. Why is it a good process? And I know it is. 2 years ago, I spoke in Dublin on this subject, and my fellow speaker, Orla Fitzgerald, produced statistics on settlement rates for construction conciliations that frankly put mediation to shame. Her reported settlement rates, and I'm afraid I don't have them to hand, they were far higher than I've ever seen in mediation. So this is a success story. Conciliation is popular and it works. Nevertheless, I do have some reservations about a process that has a built-in expectation of a recommendation. My experience is that the very fact that participants know that it's predetermined that a recommendation is going to be made in the absence of a settlement excuse me, can taint or hinder the process because it affects the 4 elements of that gold standard that I talked to you about earlier. Starting with rapport, the way you engage with a person who's going to make a decision that may affect your life, your job, or your business may be very different from the way you engage with a facilitative mediator who is there solely to help and guide you. Instead of the critical friend who may ask some awkward questions, but ultimately wants you and the other side to get the best deal you can. With a conciliator, you're interacting with someone who may be in the process of forming some very unwelcome, adverse views about your case. By the end of the day, they may be delivering some very bad news. And that, I fear, doesn't make for great rapport. I think it's also harder for the conciliator to try and feel rapport when they know they're going to be required to stand back as a neutral and make some difficult judgments later on in their recommendation. So I think rapport may be in peril sometimes. Then there's trust. How can you, as a party to conciliation, entrust somebody with your innermost thoughts and fears if they're going to be making a recommendation which may become a binding decision later on? If parties know that I'm lined up to make a recommendation, I find them far more guarded. They may mediate strategically with one eye on what I might later recommend. Of course, they want me to recommend the best possible settlement for them. And sometimes they're so distracted by that that they just go through the motions of the mediation phase because they're just concentrating on getting that recommendation. And the mediation stage may as well not have happened. They find concessions and offers very hard to make. What if they make concessions in private but the other party doesn't? Is that going to skew the conciliator's mind because they'll bank all the concessions you've made but leave open all the other points and have to make a judgment on those? It's hard to imagine that a conciliator is going to make a recommendation saying that you're bound to win a point when you've effectively privately conceded that it's a terrible point and you've got a 1% chance of winning. Your concessions don't disappear at the end of the facilitation stage. And what if you make concessions to the other party? You tell them, I'm prepared to do this in order to get a compromise settlement. Might that be translated into a finding against you in the recommendation that you get? What if you go to the very end of your authority to make a last-ditch offer? We really want to deal, we'll do this, all right, this is beyond all our legal advice, this is beyond all our expectations and the mandate we came here with, but we'll do this to get a deal. But the other side holds back something. Are you at risk then, or will you fear that you're at risk, that the conciliator will look at the remaining gap and be tempted to cut the baby in half? Well, you've moved further than the other side have, so the half is going to be more in favour of the other party. These are the sorts of things I fear people will worry about if they know there's going to be a recommendation at the other end. So your candour may count against you. And we know this happens. We know people are strategic. Often in mediations without any recommendation in place, parties strategically negotiate so that as the offers and counter offers get closer and closer, they know what the gap is going to be. So the point when someone says, oh, why don't we just split it down the middle? It's where they want it to be. They've made bigger or smaller moves at different times to get there. They'll of course do the same thing in a conciliation. So you can end up with a tendency to make no or few concessions in order to be well positioned going into the recommendation stage. So these are things that do concern me. Then there's the confidentiality. The conciliator can't unknow what they've learned during the mediation stage. Everything that you have been prepared to say privately in a mediation could become a self-inflicted wound if it plays into the recommendation. And I fear this may discourage parties from taking advantage of the confidentiality of their process. It can also be a challenge for the conciliator because you've got to grapple with taking into account things you've learnt in confidence, but not betraying them in your recommendation. It's quite an awkward tightrope to walk. And then the fourth of my gold standard indicators is the without prejudice protection of the mediation. In a mediation, if you fail to settle, nothing that you have been said can be repeated to the ultimate tribunal, the decision maker, whether it's a judge or an arbitrator. By contrast, in conciliation, everything you've said, everything you've conceded has been heard by the person who's going to make that recommendation, which is quite a tricky position to be in. I've also experienced some other obstacles in conciliation, which don't fall into those categories of my gold standard. One of them is this: parties who are anticipating a recommendation can be completely sidetracked by a perceived need to actively persuade the conciliator that they have right on their side. All they do all day long is persuade you, argue about the points to make sure you've understood that they're right and that you'll make a good recommendation. It's not just an unwillingness to make concessions, it's actually a subversion of the whole process into a mini arbitration from the outset. They want to make sure they put every argument, whatever its strength, to the conciliator, to make sure that if it comes to it, they'll get the best recommendation that they can get. And by doing that, they lose concentration on trying to get a settlement. So the recommendation becomes essential. You can't avoid it. Another problem can be that sometimes the audience for the recommendation, especially if it's a written recommendation, is different from the group of attendees at the conciliation meeting. This can be the case particularly if people hold authority from a board or from a local authority. They're really thinking, if we don't settle it and it ends up in a recommendation, how is this going to look in black and white? And that can be really important, because more than winning, you want to be shown in a favourable light. Sometimes people's jobs depend on the outcome. And these things don't always stay confidential. I've had strictly confidential processes, absolutely cloak and dagger. I've made my recommendation and read about it on a news website. So people have got one eye on what it's going to look like when other people read it. And again, that militates against the cooperation and the collaboration that you need for mediation to work. So I do have reservations about conciliation. I think it's very different if you instead have a mediation, but knowing that there's always the possibility that you could ask the mediator for an ad hoc recommendation at the end. That's much easier. It enables people to negotiate without anything hanging over them, and there's no knowledge of anything. But just being able to say, look, we've gone as far as we can. There's a really big point between us. We can't resolve it. We're going to have to spend a lot of money after today to find out what the answer is. It might be helpful if the mediator could express a view. What do you think? You know, can you help us? Can you say it's more likely than not that this point would succeed? Do you have a view as to what a good settlement can be? And that can be done formally or informally. It doesn't really matter. But the fact that it wasn't set in stone at the beginning means probably the parties have genuinely negotiated, and it's just that they failed, and then you might be able to do something. You should only do it, in my view, at the end of a process, because if parties ask you to evaluate anything as a mediator, there's a really strong risk that one or both of them will think you're an idiot. She's got it round her neck. How could she possibly think that's the right answer? It can be both parties. You know, they both thought it was a bad point, and you say it's a good point. And after that, you may lose trust. You can't then have a process where the parties are trying to persuade you that you were wrong, because once you've said what your view is, you can't start going around in circles, going back to a party and saying, oh, well, the other party has just explained why I'm wrong, I've changed my mind. So it's very much a terminal process. And in my experience anyway, parties tend to ignore it. If they don't like it, they ignore it. They go, well, we're just going to carry on as if we're right because we think you're wrong. And I suspect the reason for that is that people only ask for an evaluation if they think you're going to agree with them. That will be very valuable. If you don't agree with them, it hasn't been helpful for them, and it often brings an end to the process, not in a good way necessarily. So that's evaluative mediation. I just want to return very quickly to conciliation. Why does it work? Why is it used? I've told you about how the statistics show it does work. Obviously, if you've got a contract that says you'll do conciliation, you'll do it. That's why people will use it. But there may be other reasons. Why might it be advantageous to conciliate? Well, culturally, it may be very attractive to have somebody as a wise elder to guide you to a solution if you fail to reach accommodation. If you're going to have enough trust in that person, it may be that you're able to say, look, you've done your best to help us. We will value now your recommendations to what we should do next. And that can obviously be very valuable. It may also depend on what the alternatives are. If you don't have adjudication in your jurisdiction, you don't have DABs in your contract, you've got no prospect of getting any independent, let alone enforceable decision without spending a lot of time and money going to courts or arbitration. You may not have a court system that is speedy or effective. In TCC in England, they're great. You may not have that. You may not want to have to submit yourself to the time and cost and uncertainty of litigation. So conciliation with the possibility of a binding outcome may be attractive. You might have, for example, a public works contract which says arbitration is the forum for dispute resolution, but you can't recover your costs. So you've got a deeply unattractive prospect of arbitrating against a government body, but never getting your cost back even if you win. Again, conciliation, a quick and cheap, possibly quick and dirty outcome, gives you something that may become binding, may become very attractive. Obviously, you get into the crossover with adjudication, and I think that's another topic for another day. And I think that's probably beyond my remit. So I'm going to pause there. As I say, I really welcome your suggestions as to why conciliation works. But I'm now going to hand back to Robert, who's going to talk to us about MedArb.
Well, hello again. And I'm going to talk about MedArb and its various variants that are being tried out around the world at this time. We're in a very exciting area here because lawyers are experimenting in different countries with different models to try to grapple with a fundamental problem. This problem is that arbitration has a very big advantage over mediation in the normal way, because arbitrations result in awards which can then be enforced worldwide thanks to the New York Convention. That's wonderful. Whenever the parties who participate in arbitration are asked about it, they all complain about the length of time it takes to get that award and about the cost of getting there. And that's what makes mediation so attractive. Quick, you've been hearing about all the advantages from Rosemary. But the thing that mediation hasn't got is you can't get an immediately enforceable worldwide award to enforce your mediation settlement. Now, Singapore's trying to grapple with that, but only a handful of countries have signed up to the Singapore Protocol that will enable such enforcement to take place with mediation. So there's that fundamental problem. How can it be resolved? Well, now, as I say, there's experimentation going on all around the world. If we start with common law countries, their problem in trying to solve this dilemma that I've described is that common law jurisdictions don't like offending the rules of natural justice. They don't like things like apparent bias, and apparent bias can be very easily created if you've got the arbitrator having private confidential caucus sessions with one party in the absence of the other. And so having the same person being arbitrator and mediator immediately runs into that problem and is immediately knocked on the head as a possible solution to the dilemma I was describing. But of course, experimentation goes on all around the world, and in the Swiss, German, and Austrian jurisdictions, the solution that's coming up is to have the arbitrators able to give what are effectively determinative suggestions as to how the arbitral dispute can be resolved. And this procedure, which doesn't involve private caucus sessions and therefore doesn't create that problem that I've already described that common lawyers don't like, it's got all sorts of links to procedures that we are familiar with in common law jurisdictions, like early neutral evaluation and dispute boards. So I'm going to come back to that model, which I call the Swiss model, in a moment, and try to unpack some of the nuances there that we can take advantage of as we try to grapple with the difficulties we face. Now, another approach used in the common law jurisdictions is simply to have two separate people you have a mediator, you have an arbitrator, and you try to settle in mediation, you fail, you just park it and you go on with the arbitration. No problem there. But if you have the mediation and it succeeds, you can't get the arbitration award, and so you can't take advantage of the New York Convention. That's solved in China, and I'm going to talk about what I call the Chinese model. That's solved in China by drawing on a very long history of Confucian thinking, which encourages parties to discuss and get a deal. And it's common for, depending on which particular arbitration rules you're using, but CTAC, the primary arbitration administrator in China, uses this model all the time. And I'm told 30% of cases that go to CTAC for arbitration will get settled in Med-Arb en route. And their solution is simply to provide that the person who is going to be the arbitrator or the arbitral tribunal can be the mediator. And it seems to work. And we've got a recent case from the Hong Kong Court of Appeal, the Keating case, which I'll come back to in a moment because it's got very interesting facts. But it's clear from that China has no difficulty in dealing with this fundamental dilemma that I've been describing. It works, and the Chinese model is very successful in China. That brings me to a more recent model, which I call the Singapore model. And this is the so-called Med-Arb model, AMA. And there is a protocol on it produced by the two primary bodies in Singapore, SIAC, the arbitration body, and SIMC, the mediation body. And their model is to start with arbitration, adjourn to a mediation with a different person, so you don't have any rules of natural justice being offended. And if you don't get a deal, back to arbitration and get an award, which you can enforce. If you do get a deal, it's encompassed by the arbitration, and you can take your consent award encompassing the mediated deal and enforce that. So a very attractive model. Having outlined those, I'm now going to very quickly unpack those three key models, the Swiss-German model, the Chinese model, and the Singapore model a little more, so you can see what's on offer. You can see what experimentation is taking place, and ultimately you can see what's best for you and your clients in any particular set of circumstances. So let's take the Swiss model to start with. I've sat with Swiss arbitrators, and I've seen this work in practice very successfully. The parties are warned well in advance that what the arbitrators have in mind is that there should be a settlement meeting at some point down the line. So not the first case management conference, but somewhere further on, when the arbitrators know what's in issue, what sort of evidence is available, what the submissions are on the legal issues. And when the arbitrators are confident that they've reached that point, they check with the parties that both are content with the arbitrators giving them some guidance. No caucus sessions are held, so no problems on that front. And we all got together in the cases that I participated in, and the president of the tribunal goes through the issues and gives the tribunals feelings and approaches to those issues and suggests ways in which a deal could be put together. On some issues, it'll be vague guidance. On other issues where it's pretty clear-cut what the answer is, it'll be more determinative guidance. But it's there, it's on the table, it's for the parties to use whether in any way that they want to. And in my experience, it often does result in some sort of resolution, not necessarily the whole case, but on certain issues which clearly go one way rather than the other, the parties will simply face up to reality and take those issues off the table. That saves a lot of time because no evidence then has to be called on those now defunct issues, and the time in the hearing and the preparation for the hearing can be focused on the issues that are really an issue. And sometimes, as I say, the whole case gets settled. So it is a very attractive proposition to do that, but it does depend on the tribunal being very sensitive, because if the tribunal simply comes up with suggestions which the parties don't think shows any realism, then the parties feel that the tribunal is now biased against them. Now, in the German courts, for example, that's catered for. You can't challenge arbitrators simply for going through this settlement process. And so the fact that the courts are supportive of that process means the arbitrators in those jurisdictions feel confident about using it. Now, as I say, there's quite a lot of spin-off into other procedures that you'll all be familiar with, like early neutral evaluation. I know of one recent UK early neutral evaluation, ENE, which was very successful, where a big sports stadium had generated a lot of disputes, and a very senior practitioner in the construction world, very highly regarded lawyer, was brought in for one day and the whole case settled. In that day, there was no time for evidence, but people could outline their cases. And at the end of it, he said, well, it looks to me like certain millions are going to pass from A to B. And the parties were able to go away and settle what otherwise looked like a very messy, intractable dispute involving lots of costs. So that's very similar to what I've been describing as the German model. But because it was in England, it was done with a third party, not done by the arbitrators themselves. Similarly with dispute boards. I often sit on dispute boards, and again, you don't have, at least not if you're being very careful, you don't have private sessions where secrets are revealed to you with one party, and then you have that knowledge when you have to give an award against the other party. But often, in the course of the discussions in a dispute board, you'll be able to understand what's going on, make suggestions for how things can be sorted out. And if they can't, then you go into adjudication mode and you do make a decision. So all of those things play into each other, and it means that we in common law countries are in fact familiar with that sort of procedure that is being used so widely in Swiss and German and so on arbitrations. Now I'd like to come finally to, not finally, but very quickly to the Chinese model. I've mentioned how successful that is in China. Often the procedures there look unusual to common lawyers. In the Kenai case, which is called Gao Haiyang against Kenai, 2011, very interesting facts. Parties in arbitration, a mediation gets set up and it takes place in a local hotel, the Shangri-La. One party doesn't attend at all, so there's a mediation. The arbitration rules that apply allow the tribunal or the president of the tribunal to be the mediator. But on this occasion, they brought in a third party. There was a mediation, suggestions for settlement were made, nothing came of it. It goes to arbitration. Eventually, there's an arbitration award. The party that has to pay doesn't like it and objects at an enforcement stage about apparent bias because of the mediation. It's upheld by the Chinese court, then goes down to Hong Kong. First instance, Hong Kong court doesn't like what's happened, goes to the Hong Kong Court of Appeal, who say the Chinese courts know what they're doing, they know the local procedures. The fact that one party wasn't there at all is something that the local courts would have taken into account when they upheld it. And so the Hong Kong Court of Appeal upheld it as well. So it shows what flexibility there can be when different jurisdictions are bringing their own backgrounds and nuanced legislation and so on into play. And that brings us finally to the Singapore model. I must say this is one that attracts me because it is building on blocks that we're all familiar with. What you do in the Singapore model, there's a June 2015 AMA-Arb Med-Arb protocol that has it all set out. You start the arbitration, you adjourn, you go off to mediation with a different person, so you don't offend the rules of natural justice. If the mediation succeeds, then you've got a deal, you put it into a consent award, the arbitrators issue it, you can enforce it worldwide. If you don't get the deal, you come back to the arbitrators, entirely different body, and you go on with arbitration in the usual way. I've mentioned that the two key bodies in Singapore, SIAC and SINC, have got the protocol. They've got model clauses that you can put into your dispute resolution clause at the outset when drafting the contract, and that enables you to get the deal. So watch that space. I think that particular protocol, its time has come. But it's also my time has come because my presentation's concluded, but we're now going to move to questions and hopefully answers. And so I hope you've been sending those in, and we're going to go to Ollie now, who is going to deal with those.
Thanks very much, Robert. Yes, the questions are coming in, so we'll try and get through as many as we can. So we'll start straight away. Rosemary, if I could come to you first, there's some questions that you've probably seen about the qualities that you would maybe look for in a conciliator, and also Stephen Tennant has kindly put some thoughts there about the difference between conciliation with a recommendation and evaluative mediation. I just wondered if you wanted to explore a bit more about those points on there.
Yeah. Can you hear me and see me?
Yes.
After the earlier glitch. I got very excited to find there was lots of questions, but then the first 15 or so were to say people couldn't hear me and then that they could. So thank you all for those. Yes, 2 points in particular that I'm very grateful for suggestions have been made. Stephen Tennant, thank you. On the question of facilitative versus evaluative mediation, you've said you offer the possibility if you feel willing at the end of a mediation and both sides agree, you'll provide a non-binding evaluative report, which can't be used in subsequent proceedings. I agree with that. I do that as well. I have that in my terms. And I think what you said is really important. If you feel willing, I don't think you can ever bind yourself in advance, or you shouldn't, to giving a particular evaluation, because there are lots of things that people have talked about where frankly you don't have the information. Even at the end of a mediation, you're simply not able to say, I think this is what the answer is. There's so much up in the air, the experts haven't looked at points. So yeah, I think it can be helpful, but it's very important that you've got to agree the nature of the recommendation, and the parties have got to agree it, so that people aren't working on the assumption during the mediation that that's what they're going to get. So thank you for that. And the other one, Peter, Scott Caldwell. Hello, Peter. Nice to see you. I can't see you, but you can see me. And you said your experience of conciliation could be described as med adjudication. In all cases, the mediation didn't result in admissions or concessions. However, the mediation was a useful fact-finding and in establishing relationships with the parties. Adjudication which followed were much less formal and resulted in a discussion, with small decisions being made by me as we reached a roadblock. These decisions were each explained but provisional. Because every decision was explained as it was made, the parties didn't ask to open up any of the provisional decisions. No formal written decision was required, and the process worked. I think that sounds great. It's a real example of working out a process with the parties that will work for them, because putting them into a straitjacket is hopeless. What will work for them is exactly the right thing to do, and clearly this did work. It obviously didn't work in the early stage for the mediation, perhaps for the reasons that I was talking about earlier. My only question would be, how do you write that down as a process? I don't think you could formalise that very easily. But thank you both for those.
If I may just also just, Rosemary, just tag on, Stephen Levinson has kindly just put a point in there, which I'd just like to ask you, which is, how do you get an admission from a party that a point is weak without stating your view, and in brackets, in a mediation? Well,
I said I'd like to answer that because before asking that, Stephen gave me a thumbs up, so he got on the right side of me. Even that's a trade secret. But actually, it's not that difficult to do. People very rarely say face-to-face, that's a bad point. But part of the mediator's skill is being able to say, well, yeah, how's that point going to run with the judge? Is that your best point? Or even, what do you think the judge is going to make of that point? And it's very hard for people then to say, oh, we think the judge is bound to say we're right. If you've got the trust and rapport that you've already built, possibility is that they'll say, yeah, we can see that that may not be our best point. And sometimes, even if they don't say anything openly, I then come back into the room half an hour later and they've made their first offer. And funnily enough, it doesn't include anything for that point because they've tacitly accepted it was a bad point. So that's all I'm going to say. It's the skill of the mediator.
Thank you, that's great. Robert, if I could come to you next with a sort of a two-parted question, because we've had a couple just in relation to the MedArb points that you were making. So the first part is a question which has said, if the contract has an arbitration clause but says nothing about mediation or MedArb, how can I set up a MedArb? And then just another point with that, my client's contract specifies MedArb, but doesn't specify any particular procedure. Are there any suggestions?
Right. Well, very interesting questions because they arise so frequently. The standard dispute resolution clause in a construction contract, and as you know, Keating Chambers, that's what it does. Construction, and so that's where my experience is. And if you look at any construction contract, the chances are it's got an arbitration clause rather than sending you off to litigation, but the arbitration clause will simply say arbitration. It won't be nuanced and say things like mediation. Sometimes nowadays there are these tiered clauses which permit mediation, but generally they don't refer to mediation, and they certainly don't, in common law countries, refer to MedArb. So, having listened to what you've heard this morning, you may now all be enthusiastic to try out Arb, MedArb, or whatever it is, to see how it works for you. And you tell your clients about it, they're enthusiastic, but it's not in the contract. So what do? Well, the first thing is, if you can get it into the contract right at the outset, then of course do so and use the clause, as I've mentioned, that embodies, for example, the Singapore protocol, because that will solve the problem. But if you haven't got that, you've got to start from scratch and set up an ad hoc procedure when the dispute arises. Now, this can be difficult because once the dispute arises, parties are very reluctant to agree with anything the other side suggests because they think there's some deep ulterior motive there. But with competent, confident lawyers, you can often get an agreement on a procedure. And if you do go for a procedure, then, as I say, I would suggest this Med-Arb Med procedure is one to look at. Start with the mediation, adjourn to, start with an arbitration, adjourn to the mediation, back to the arbitration at the end. And because it's got a good track record, it's been around since 2015, and people who've used it all speak very highly of it. I suspect you can get a deal to use that, and if you do, that's the way to go. And I think that actually answers both questions. That's what I suggest you do.
Excellent, thank you very much. Rosemary, if I may just come on to you. Leon Smith has proposed a question just a moment ago, which says, is there not scope to have a traditional mediation and then just submit an agreed settlement to an arbitration for a consent decision to engage the New York Convention?
Yes, that's the thought in my mind. And quite often people have started an arbitration already. Then when they get a mediation, they send the settlement back to have a consent award from the arbitrator so that they can enforce it. Just as if they're in court proceedings, they'll put their settlement agreement into a Tomlin order, send it off to the court, and so the proceedings are stayed except for the purpose of enforcing the settlement agreement. And then of course, even without doing that, if you're covered by the Singapore Convention, then you can have enforcement rights of your mediation settlement agreement.
Could I just chip in with a nuance on that? When that was debated in a conference that I'm aware of, some learned lawyers said, if you simply start with the mediation, as opposed to starting with the arbitration, if you start with mediation and you get a deal, then you go to an arbitrator. The arbitrator cannot have any jurisdiction because arbitration clauses give jurisdiction for disputes. But once you've settled in mediation, you don't have a dispute, so you can't ever start. And it's to get over that problem that Singapore has so cleverly said, start with the arbitration, then adjourn to mediation, and so on. But yes, it's a good thought.
I agree with that. Yes, you can't just start the arbitration afterwards. But you don't have to do much to start it in advance and then have those advantages.
Excellent. Thank you both. Robert, there's a question that has come in for you particularly, which says, if my Chinese clients ask for a Med-Arb where the arbitrator is the mediator, what should I do?
Chinese clients are very keen on this because, as I've mentioned, it is so successful in China. I mentioned that CTAC statistic that 30% of the cases that start with them as arbitrations get settled using their Med-Arb model, which involves the tribunal being the mediator as well. I would say the first thing to do is, where is your arbitration seated? If it's seated in China, anywhere, Shanghai, Beijing, wherever, you have no problems. The courts there are totally familiar with that procedure. And so if that's where your seat is and your Chinese client asks for it, you use the CTAC model and away you go. And I've mentioned the Kenai case, which shows that it should proceed without any difficulty. However, if you're in a common law jurisdiction, you need to be more careful. Now, Hong Kong is fine. The Hong Kong Arbitration Ordinance actually caters for Med-Arb in the Chinese style. So if you're there, you're okay. There's very little take-up of that particular procedure in the ordinance because a lot of Hong Kong lawyers are so conscious of the difficulties that can arise with breach of the rules of natural justice. So if you're in Hong Kong, you may be okay. If you're out of Hong Kong, you need to be very careful indeed, because that model of the same person doing the mediation and the arbitration immediately hits all the difficulties that Rosemary so eloquently described in her presentation. And so I would be very reluctant to help my Chinese client have a Med-Arb in that sense. I'd rather persuade him to use the Singapore protocol of Med-Arb, AMA. Thank you.
Thank you. Like any good host, I'm going to see if I can just squeeze in one more question for everybody, which is that Tim Hill has kindly put down, and Robert, you actually glanced across the Hong Kong Ordinance there. But Tim has just said, and I just wondered if you both have any quick views on this final question, which is, do you consider that a provision like S66 of the Hong Kong Ordinance should be more widely adopted? It provides that if the parties to an arbitration agreement settle their dispute and enter into an agreement in writing containing the terms of settlement, the settlement agreement is, for the purposes of its enforcement, to be treated as an arbitral award. And I just thought, as a closing, maybe if you've got any views on that.
I'll kick off on that. That is absolutely. The Hong Kong Ordinance is, again, ahead of its time. And that procedure is not very different from the AMA procedure in Singapore. The AMA is slightly different in the sense that it gives, I think, 8 weeks for the mediation to take place, and then you have to come back to the arbitration. But this section 66 in Hong Kong is modeled on that, or is modeled on its own procedure using the Chinese background, because it says if the parties to an arbitration agreement settle their dispute. So you've got the arbitration agreement there, and I'm assuming you've started the arbitration, you've then got your mediation settlement, you can then take it off and it will be an arbitration award. So yeah, very good.
Excellent, that's great.
I don't think I have anything to add to that, really.
Great, perfect, that's great. Well, I'm afraid that's all we've got time for. And I'd just like to thank you all for joining us today and for posting those excellent questions. Thank you to Robert and to Rosemary for being such excellent speakers and for the detail that you shared. So thank you so much for that. I understand from our excellent marketing team that they will be circulating a recording of this session later on today, and that our next webinar will be in 2 weeks' time. So we do hope that you can join us for that in 2 weeks' time. Thanks again to everybody. Do take care, and we look forward to seeing you soon. Thanks very much.
Bye-bye.